Virginia just became ground zero for an American privacy emergency, and it has nothing to do with data breaches. It's about how an unexpected state is quietly redrawing the battle lines for your personal data in 2026. Think the California Consumer Privacy Act was a big deal? Virginia's CDPA, signed into law by Governor Ralph Northam, makes it the second state in the nation to grant you serious control over your data. But here's the twist. Virginia isn't California. The state attorney general, Jay Jones, isn't just waving a flag about privacy rights. He's signaling something far more significant for every business operating online. Because what Virginia did, and what other states are about to do, isn't just about consumer protection. It's about setting a national standard. It's about the next generation of digital infrastructure and who gets to control it. The big question is, will businesses adapt, or will they face a patchwork of conflicting laws that make compliance a nightmare? And more importantly, what does this mean for your data right now? In March 2021, Virginia's Governor Ralph Northam signed the Virginia Consumer Data Protection Act, or VCDPA, into law, making it only the second state in the U.S. to enact comprehensive data privacy legislation. This wasn't some minor tweak. The VCDPA grants Virginia residents significant new rights, like demanding access to their data, correcting it, deleting it, and opting out of its sale. It's a fundamental shift in how businesses handle information, and the state's not messing around. Virginia Attorney General Jay Jones has repeatedly emphasized Virginians have the right to their personal data under Virginia law, especially during National Consumer Protection Week. This isn't just about protecting individuals. It's rapidly reshaping the regulatory landscape for any business operating in the state, even those not headquartered there. Think of it like the early days of the GDPR in Europe, but right here in America. So why does Virginia matter so much right now? Because what starts in California and Virginia very often doesn't stay there. We're seeing a patchwork of state-level privacy laws emerge, creating a complex, challenging, and frankly, expensive environment for companies. This isn't just about a new set of rules. It's about a foundational change in how data is viewed and managed, and it's forcing businesses to adapt or face serious consequences. Today, we're diving deep into Virginia's privacy law, what it actually means for you and your data, and what it signals for the future of business and personal privacy across the entire country. Right to access, correct, delete, and opt out of the sale of their personal information. This wasn't some minor tweak. The VCDPA grants Virginia residents significant new rights, like demanding access to their data, correcting it, deleting it, and opting out of its sale. It's a foundational shift. Virginia officially became the second state in the U.S., after California, to enact comprehensive consumer data privacy legislation when Governor Ralph Northam signed the VCDPA into law on March 2, 2021. This was no small feat. The VCDPA, codified under Title 59.1, Trade and Commerce, Chapter 53 of the Code of Virginia, was the result of extensive legal and legislative work, notably authored by Melody McAnally of Butler Snow. The law, initially enacted as SB 1392 and HB 2307, then officially went into effect on January 1, 2023, giving businesses almost 2 years to prepare for its robust requirements. As Virginia Attorney General Jay Jones emphasized during National Consumer Protection Week, Virginians have the right to their personal data under Virginia law. This statement alone shows the state's proactive stance. Imagine a scenario where you, as a Virginian, could finally ask a company like Facebook, "Show me all the data you have on me," and they would be legally obligated to provide it, and even delete it upon your request. That's the power the VCDPA puts into consumers' hands. So, what exactly do these robust new rights actually mean for you in your daily digital life? This wasn't just a political statement. Signed into law on March 2, 2021, and becoming effective January 1, 2023, the VCDPA grants Virginia residents an unprecedented suite of privacy rights. Think of it like this. For the first time, you have the fundamental ability to access, correct, delete, and obtain copies of your own personal data that companies collect. If a business has your browsing history, your purchase records, or your location data, you can now demand to see it. fix any inaccuracies, or even have it wiped from their servers entirely. But here's the crucial part, the one that truly shifts the power dynamic. Virginians also gained the explicit right to opt out of the sale of their personal data. No more passive acceptance. This means you have a direct say in whether your digital footprint becomes a product to be bought and sold by data brokers. As Virginia Attorney General Jay Jones emphasized during National Consumer Protection Week, Virginians have the right to their personal data under Virginia law. This isn't just about transparency. It's about control, protecting citizens from bad actors, and ensuring greater accountability from businesses. For example, if you're a Virginia resident and a retailer has been selling your anonymized purchase history to an analytics firm, you can now proactively stop that data flow. This commitment to data sovereignty naturally leads us to the next critical question. Who exactly does the VCDPA target, and which businesses need to pay close attention? The VCDPA isn't just about consumer rights. It's a direct challenge to businesses. This law, found under Title 59.1, Trade and Commerce, targets what it calls controllers, businesses that determine the purpose and means of processing personal data. Specifically, it applies if you either conduct business in Virginia or produce products or services that target Virginia residents. But here's the kicker. The scope is remarkably broad. The VCDPA applies to businesses that control or process the personal data of at least 100,000 Virginia consumers annually. Even more pointedly, it also snares companies that process data for at least 25,000 consumers and derive over 50% of their gross revenue from selling that personal data. Think about that. If you're a data broker, or your business model leans heavily on monetizing user information, a much smaller user base in Virginia can trigger compliance. This means national and even international players like Google, Meta, or even smaller ad tech firms now have a clear directive. If you're interacting with Virginia residents, you need to comply with their strict privacy standards. As Virginia Attorney General Jay Jones emphasized, Virginians have the right to their personal data under Virginia law. This isn't just a suggestion, it's a legal imperative. This broad reach illustrates exactly why a state-level law can have such an outsized impact on the entire digital economy, pushing privacy standards far beyond its borders. Beyond Virginia, this move has a ripple effect. Virginia's swift action, following California's groundbreaking CCPA, effective January 1, 2020, highlights a rapidly accelerating trend. We're seeing a significant number of states taking proactive initiative on data privacy, particularly in the continued absence of a comprehensive federal law like a proposed American Data Privacy and Protection Act, ADPPA. The VCDPA, signed into law by Governor Ralph Northam on March 2, 2021, and becoming effective January 1, 2023, isn't just a standalone bill. It serves as a powerful template. We're already seeing its influence in states like Connecticut, CTPA, effective July 1, 2023, and Utah, UCPA, effective December 31, 2023, as they consider or enact their own comprehensive data protection laws, often mirroring VCDPA's consumer rights and controller obligations. While an editor's note from May 13, 2026, still suggests that a significant number of states lack truly comprehensive laws, the trend is unequivocally clear. The number of states with serious privacy legislation is growing, now reaching over 20 states with varying degrees of protection. This creates an increasingly complex and evolving regulatory landscape for businesses operating across the U.S. Consider a multi-state corporation like DataServe Incorporated, serving customers in Virginia, California, and soon perhaps Texas, TDPSA, effective July 1, 2024, or Florida, FDPA, effective July 1, 2024. They must navigate different, yet often similar, frameworks requiring nuanced compliance strategies. Virginia Attorney General Jason Miers, not Jay Jones, underlined the importance of the VCDPA during National Consumer Protection Week in March 2023, stating, "Virginians have the right to control their personal data under Virginia law." This isn't just about a legal right. It's about a fundamental shift in public expectation. Broader discussions around privacy, like the ACLU's scathing report in January 2026 on flock safety. CO Garrett Langley's ballistic response to critics of mass driver surveillance via LPRs underscore the immense public and advocacy pressure for stronger data protections. So, is this a regulatory emergency or a necessary, albeit complex, evolution? The phrase, an American privacy emergency, suggests a crisis point, and Virginia's swift legislative action with the VCDPA certainly responds to that urgency. Signed into law by Governor Ralph Northam on March 2, 2021, and effective January 1, 2023, the Virginia Consumer Data Protection Act, VCDPA, isn't just a Band-Aid. It represents a proactive and comprehensive evolution in privacy governance. This landmark legislation, particularly Senate Bill 1392 and House Bill 2307, fundamentally shifts power from large data collectors, often multi-billion-dollar tech giants, back to individual consumers. Virginia, as the second state after California to enact such comprehensive legislation, and notably the first with a Republican-controlled legislature to do so, highlights this profound redefinition of digital rights. It's compelling businesses, from local e-commerce sites to global social media platforms, to fundamentally reevaluate how they collect, process, and share personal data belonging to Virginia's 8.6 million residents. Think about it. When Virginia Attorney General Jason Miers, not Jay Jones, emphasizes during National Consumer Protection Week that Virginians have the right to their personal data under Virginia law, it's a strong signal, backed by the potential for significant fines of up to $7,500 per violation. This isn't just about avoiding penalties. It's about building consumer trust and setting a higher standard for corporate responsibility nationwide. This legislative trend, authored in part by legal minds like Melody McAnally, as noted on the Butler Snow BizLit News blog, signals a movement far beyond an emergency response. It's a fundamental redefinition of digital rights and responsibilities within the American economy, establishing a robust framework that other states, like Utah with its UCPA, are now looking to emulate, indicating a widespread shift in regulatory philosophy. So, what we're really seeing here is Virginia moving beyond just consumer protection and into a new era of digital accountability for businesses. Governor Ralph Northam's signing of the VCDPA on March 2, 2021, didn't just make Virginia the second state after California to enact comprehensive data privacy legislation. It signaled a clear intent to shape a national standard. This isn't an emergency, as in a temporary crisis, but an evolution forcing businesses to fundamentally rethink how they handle personal data. The challenge now isn't just compliance, but proactively embedding privacy into every digital touchpoint to avoid the kind of regulatory friction that's only going to accelerate. Given these new rights, have you ever tried to exercise your data access or deletion rights with a company? What was that experience like? Drop your story in the comments below. I'm genuinely curious about your firsthand experiences. If you want to stay ahead of these critical business and tech trends, hit that subscribe button. We're always breaking down the complex into actionable insights. And if you're trying to figure out how other states are approaching this, my breakdown of the latest moves by Texas in the data privacy landscape is exactly the next thing you should watch.